Right away, you can feel the weight this judge is carrying. He's not just throwing out numbers, he's weighing lives, trauma, and law. This isn't some cold system. It's someone trying to make sense of irreversible damage.
Before imposing sentence, the court's going to note for the record that I have considered the entire record, including the trial, testimony from all of the witnesses, including each of the defendants. The oral statements made here today, the pre-sentence investigation reports, the victim impact statements, and the statements from Mr. Deaver and Davis's mom. I've also considered the letters from family members that I've received and reviewed. And I have formulated my decision based upon the overriding purposes and principles of felony sentencing, namely to protect the public from future crime by the defendant or others, as well as to punish the offender using minimum sanctions that I determine accomplish those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, I have considered the need for incapacitation, deterrence, rehabilitation, and providing restitution. I must and I have considered the seriousness and the recidivism factors relevant to the offense and offender pursuant to Revised Code 2929.12. The court must and I have ensured the sentence being imposed does not demean the seriousness of the crime, the impact it has had on the victims, and is consistent with other similar offenses committed by like offenders. Finally, Mr. Deaver and Mr. Davis, the sentence I'm going to impose will not be based on any impermissible purposes, namely your race, ethnic background, gender.
And then it hits, the judge lived in that same area. He's not buying the "we were just trying to survive in a war zone" defense. That lie crumbles fast. It's not just a legal takedown, it's a personal one.
Or religion. Do each of you understand that, Mr. Deaver and Mr. Davis? Okay. So before I impose sentence, I wanted to say a couple of things. This was a tragedy, and there's no doubt in my mind that every single person in this room, sitting on both sides of this aisle, loved and cared for both not only Gracie Griffin, but also Mr. Deaver and Mr. Davis to some degree. But the fact of the matter is we're here because of a mistake that you made. We're here because of a terrible mistake that you made. And one of the things that bothered me throughout the trial testimony was this notion that the two of you live in a neighborhood filled with drive-by shootings and high crime and murders. You don't, okay? I lived in the city of Cleveland for almost 20 years. I lived in West Park, which is where you were. And I understand that a friend of yours was shot off of Trowbridge Avenue over near, I think it was West 38th Street, I think was the cross street that I had heard during trial testimony. But 38th and Trowbridge is not anything resembling 126th and Triscuit. That's a fairly quiet neighborhood. And while maybe it's not as peaceful as other parts of West Park, it is not the crime-ridden hellscape that the two of you testified to at trial. So that bothered me to some degree.
This is the part that's almost unbearable. The people in that car, they're friends, not enemies, not strangers. These weren't targeted shootings. They were tragic betrayals masked by paranoia or bravado.
The other part of this too is the individuals who were in the car were friends of yours. There was no testimony to the contrary that Mr. Stevens, Ms. Jackson, Ms. Rivera, and Ms. Williams were not friends of yours or targets of any kind of shooting. This was a mistake, a tragic mistake that had tragic consequences.
This section gets technical, but it shows how layered the justice system can be. Every bullet, every decision, every firearm spec, it all adds up. These aren't optional penalties. The law requires stacking them, and the result is brutal.
For the family of Gracie and for your families, is I'm required to give you a mandatory sentence here. So the court's going to sentence you as follows. I want to note for the record that none of these counts merge for the purposes of sentencing, so the court is going to impose a sentence on each count. that I also must note that pursuant to Ohio Revised Code, Section 29.14B1G, as well as the presiding case law, State versus Baller, 22 Ohio 4310, that I am required to run the two of the 3-year firearm specifications consecutive with each other, regardless of any underlying merger. So the court's going to sentence each of you as follows. In count 1, the sentence is going to impose 3 years on the firearm specification, which must be served prior to and consecutive with a sentence of 15 years to life. In count number 2, I'm going to sentence you to a 3-year firearm specification, which must run prior to and consecutive with the 2-year sentence I'm going to impose on the felonious assault, and consecutive with the 3-year specification in count number 1.
25 years to life. Let that sit with you. 2 young men, now locked into a future that may never come. And all of it, from the judge's tone, feels like something that could have so easily been avoided.
In count number 3, felonious assault for Micaiah Jackson. Count 2 was Jameer Stevens. Count 3 for Micaiah Jackson, I'm going to impose a sentence of 2 years. Count 4 for Giselle Rivera, I'm going to impose a sentence of 2 years. Count 5, with regard to Edgewan Williams, I'm going to impose a sentence of 2 years. Count 6 for improper discharge into the habitation of Bella Ben, I'm going to impose a sentence of 2 years. In count 7, the discharge on or near a prohibited premises with regard to serious physical harm to persons, I'm going to impose a sentence of 3 years. And in count 8, the discharge on or near a prohibited premises creating substantial risk of harm to property, I'm going to sentence you to 1 year each. I will note for the record that counts 2, 3, 4, and 5 will run concurrent with each other. Counts 7 and 8 will run concurrent with each other. And counts 1, 2, and 6 will run consecutive with each other for an aggregate sentence of 25 years to life. I'm going to note that the court finds consecutive sentences are necessary to protect the public from future crime and to punish the offenders, and that the consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offenders pose to the public. And I find, with regard specifically to Mr. Deaver, that at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses committed was so great or unusual that no single prison term for any of the...
The judge isn't just sentencing them for one act. He's breaking it down. Friends in the car, shots over a roadway, bullets into homes. This wasn't random chaos. It was recklessness with deadly consequences.
Any of the offenses committed as part of any of the courses of conduct adequately reflect to the seriousness of the offender's conduct. And actually that will apply to both Mr. Deaver and Mr. Davis. But specifically to Mr. Davis, I'm also going to find that the offender committed 1 or more of the multiple offenses while he was awaiting trial or sentencing or under a sanction imposed pursuant to section 29, 29.16, 17, or 18 of the revised code. That's because, Mr. Davis, you were on probation to Judge Bell for having a weapon while under disability. The reason I'm giving consecutive sentences, I'll note, is that there's 3 groups of victims here. There's Gracie Griffin, the 4 individuals who were in the car. I believe that shooting at them deserves its own sentence, and the fact that you shot over a roadway on a busy and dense residential street, resulting in 1 of those bullets striking through a home, merits its own sentence as well.
Even at the end, the judge gives them dignity, appoints appeal lawyers, waives court fees, acknowledges their hardship. It's justice, but it's also humanity. And that's something we don't always see in courtrooms.
I do want to advise both of you that you have the right to appeal your conviction and sentence, and that's pursuant to Criminal Rule 32B. And I will advise the following: if you're unable to pay the cost of appeal, you have the right to appeal without payment. If you are unable to obtain counsel, counsel will be appointed without cost. If you're unable to pay a document cost of appeal, the same will be provided without cost. Each defendant has a right to have notice of appeal timely filed on his or her behalf, and upon your request, I will appoint counsel for appeal. Now, I spoke with Mr. Martin. I'm going to appoint counsel for both of you. Mr. Deaver, I'm going to appoint Susan Moran to represent you on your appeal. And Mr. Davis, I'm going to appoint Joe Pagano to represent you on your appeal. I'm also going to find that both of you are indigent. I'm going to waive your court costs for both of you. Mr. Deaver, you're going to be given credit for 356 days served. Mr. Davis, you're going to be given credit for 348 days served. Because this is a life sentence, I am not required to read and review the terms and conditions of post-release control. Mr. McNair, is there anything else on behalf of the state of Ohio?
No, Your Honor.
Mr. Bradley, is there anything on behalf of Mr. Deaver?
No, Your Honor.
And Mr. Cumpstone, anything on behalf of Mr. Davis?
No, Judge.
I want to thank all of you again for your time and care, and I want to thank everybody in the room for their decorum.